and the other panelists on Zoom. If you listen to the case that they are making, in principle, I can understand why they are taking that approach, which is there are still unresolved. Yes, the determination has been made. The committee has made its findings. The president has acted in consultation with the Council of State, and the CJ has been removed. The acting CJ has now been nominated for the substantive role of CJ, which now requires a vetting before Parliament. But if I understand the minority correctly, there are still legal processes that have been instituted or initiated against the entire process that needs resolution before a vetting can proceed. In principle, I can understand that, right? That to go ahead with the vetting may seem to suggest that you know what the court is going to decide with these cases. Now, we also don't know, I mean, we don't know what the court will say or not say about this. But I think when we are talking about the entire governance environment, and letting institutions work the way they are designed to work, for me, it doesn't, quote unquote, spoil anything if you let those judicial processes takes its course before you do the vetting, so that in a way you are sort of not prejudicing what you think the court would say or not say, or what you think the court would.
You want them to speak when the stable's doors have been shut?
Say that again, Samson.
You want them to speak when it is too late, to act when it is too late?
In terms of the courts to act when it is too late?
Yes, they are taking a preemptive strike. You are saying, oh, it's okay to just relax and let the vetting go on and then let the court processes go on. Is that what I understood you to say?
No, what I'm saying is that it doesn't spoil anything to put the vetting on hold and allow the court processes to come to a finality, so that you don't sort of prejudice what you think the court would do or not do. That is my position on the minorities.
But the Chief Justice, the Chief Justice Gertrude Torkornoo has been removed.
Correct.
So what's standing in the way of a replacement?
Well, I mean, yes, she's been removed. There's an acting in place, and what I'm saying is that transitioning the acting into a substantive role is running into this issue where the minority is saying, well, there are court processes against that removal. Can we wait for those court processes to be fully resolved before we move ahead with the vetting? In principle, I don't think there's anything wrong with a position like that, because proceeding then would sort of assume that you know what the court would say or how the court is going to rule on the substantive matter before them. And I would want to sort of avoid that kind of prejudice thinking with regards to what you think the court would do or not do. I'm not one to read motive into the things that people do, but do I also believe that there's an element of politics around this? Yes, because of the minority's position again on this entire removal process, that I believe part of it also has to do with extension of that grievance. But when you put the politics as well as the principled issue of let the courts resolve all of this fully before we move ahead with the vetting, I can see why they would take that kind of position.
Kweku Pinto,